Good morning to one and all. And now we are going to share the legal research methodology. 12 ingredients are significant in legal research methodology. First, we should know what is legal research. Then, second, what and why of legal research. Third, what is legal knowledge. Fourth one is what are the sources of law. Fifth one is what is mean or what is the definition for statute, its nature and structure of statute is essential. Sixth point is interpretation of statutes is significant. Seventh point is modes of legal research. What are the modes of legal research is essential. Eighth point is research process. What is the research process? How it should be done is dealt in the research process. Ninth important point is case analysis, advocacy, and legal research. This is the spirit of legal research methodology, and in every research methodology also. It denotes the common sense application of mind is more needed in this legal profession. So that ninth important point, every legal research methodology should be based on case analysis. Along with that, advocacy. In court of record judgments, we are seeing that justices appreciation of counsels at their judgment writing. That's called as art of advocacy and pleading. So case analysis and art of advocacy and pleading, and the legal reasoning is very essential ingredient. After that, 10th important point is observations. 11th is we should know what is social survey and what is sampling. This is in 360 angle, every field should be internationally done, but in legal research methodology also, and counsel or an advocate or a pleader should know that social mapping and sampling. 12th ingredient is questionnaire and schedules. We should know how to, and we are commonly telling leading questions with answers of yes or no. It's a basic. Likewise, in every legal research methodology, we should ask every counsel or every advocate should ask the questionnaires themselves and towards the solutions in research methodology paper presentations. And also, uh, 13th important ingredient is report writing. We should know the conclusion. Before conclusion, we should know the report writing. What are all we have um, acquired through the questionnaire, we should finally represent report writing. Then 14th ingredient in this digital era or computer era, we should know the computer application and legal research relevancy. So 14 ingredients are essential in legal research methodology. For example, I am sharing the legal research methodology introduction given by Dr. H.N. Diwari. H.N. Diwari. Dr. H.N. Dewarihi is a Allahabad law agency based book released by Dr. H.N. Diwari in the title of Legal Research Methodology. It's a noble book in my experience. First edition in 1997. In his previous, he explains what this kind of 14 ingredients detailed. So we should share one by one um, with the aspirants. Research is an important means of acquiring new knowledge and truth about a subject. It provides an opportunity for improvement. It provides an opportunity to mold the course of an idea, thought, and perception. But there is no shortcut to it. One is supposed to deeply involve with it. it requires a lot of patience. One will have to walk uneven terrain. So now we can understand the significance of research. Then next, in the field of law, research occupies a very significant position. As we know that law is not only a means to maintain law and order in the society, but it is also the means of providing social justice and implementing welfare schemes. We are also aware that the law does not operate in vacuum. It is an important thing. We are also aware that the law does not operate in a vacuum. ஒரு வெற்றிடத்தில் without human beings there is no need of a law. So we are also aware that the law does not operate in vacuum. It operates in society, which is itself influenced by various factors such as social structure, economic condition, nature of government, scientific inventions, and the outlook of the people towards life. With the advancement in the means of communication, different cultures are coming together to give birth to new thoughts and way of life. In other words, societies have become complex and complex problems are arising in it. It is I feel that during my law college 2005 to 18 at Madurai Government Law College, all the professors have ignited this point. Societies have become complex and complex problems are arising in it. This is the reason for the law is a evolutionary discipline. To solve the complex problems, the law must be up to the mark. It must have the capability to tackle the problem. This capability can be acquired by it only through research. So the need of evolutionary of legal research along with the contemporary complex problems is discussed in this paragraph. Next one is in the field of law, research work is carried on not only by the students but also by the judges and legal practitioners. It would probably be more appropriate to say that the judges and legal practitioners do more research work than law teachers and students. Every problem undertaken by legal practitioner demands from him a lot of thinking and study so that he may impress the court to believe his statements and disbelieve his opponent's view. The judge is not wholly dependent on what has been said by the opposite legal counsel. He does his own thinking and study before arriving at a particular conditions. Both judges and legal practitioners obtain their materials from the previous judgments and writings of other legal experts and from statutes, and then they formulate an opinion to arrive at a conclusion. Legal luminaries like Bentham, Austin, Kelson, Pound, Savigny, etc., have thrown considerable light as to how law should function by dint of their studies. Bentham, Augustine, Pond, etc. have lent their support to the law made by the legislature, whereas Holmes, Cardozo, etc., have supported the judges as a source of law. Savigny, Maine, etc., have supported custom as a source of law. These diversions in their view is due to the fact that they were convinced from their studies that this is the way how a good law can come into existence. Judges have pronounced many new principles of law while pronouncing judgments. This fact is amplified out of one looks to some lending judgments pronounced in the course of time. Example, Ryland versus Pludger, Tonak versus Stevenson, Carrill versus Carboly Smoke Ball Company, Hardley versus Baxendale, Mercy Dogs Trustees versus Gibbs, Priestley versus Fowler, Grafters Handon Harris Feed Company versus Welch, Constantine versus Imperial Hotels Limited, Brown versus Board of Education, Stockdale versus Hansard, Bradford Corporation versus Pickles, Manara Gandhi versus Union of India, and MC Mehta versus Union of India, etc. The development and growth of law is a constant process. Therefore, constant study and research is essential. The scientific inventions and new philosophical approaches are challenging the law every day. The problem of social justice, the problem of paternity, the problem of embryo testing, the problem of consumer protection is yet to be solved on a realistic footing. Research is the only tool which can solve or at least can provide an appropriate answer to these questions. Broadly, research methodology is divided into doctrinary and empirical research. In the field of law, doctrinary approach plays dominant role in contrast to empirical approach, which depends on surveys, sample testing, questionnaires, schedules, interviews, etc. The empirical approach is now gaining recognition, but it has yet to travel a long distance before it can play substantially useful role. The entire process of carrying on research is very tiring, time and money consuming. The modern supersonic device, the computer, is not yet of much help in the field of legal research, probably due to non development of appropriate language. So far, its role is confined to storage and retrieving of cases. The work for developing appropriate language is going on in many countries, and it is hoped that in due course an appropriate legal language would be evolved and then this device would be of significant use. However, there are certain hurdles which cannot be solved easily either by human beings or by computers in this legal field. They are: number one, human behavior changes so much from one period to the next to permit exact predictions. Number two, human behavior is too clusive, subtle, and complex to yield to the rigid categorizations. Number three is human behavior can be studied only by other human observers, and they also distort fundamentally the facts being observed so that there can be no objective procedures for achieving the truth. Number four, human beings are the subject to some predictions and have the ability deliberately to upset any predictions that can be made. A research work in the field of law should be conducted in the light of the above facts. In the preparation of this work, we should sought the help of many works given, and we should these three points should be considered timely. In a legal research methodology, number one, human behavior changes so much from one period to the next period to permit exact predictions. So we need a legal research methodology. Number two, human behavior is too clusive, subtle, and complex to yield to the rigid categorizations. So we should do the legal research methodology paper presentations. Then third ingredient is human behavior can be studied only by other human observers, and they always distort fundamentally the facts being observed. So thus there can be no objective procedures for achieving the truth. This is important ingredient. Fourth one is human beings are the subject to some predictions and have the ability deliberately to upset any predictions that can be made. A research work in the field of law should be conducted in the light of all the above facts. Once again, I summarize all the points. The legal research methodology should be done with the tools of studies of research, giving a significant um, ingredients such as what is legal research, first ingredient. Second, what and why the legal research should be done in a particular topic. Number three, what are the legal knowledge should be acquired in that topic. Fourth one is what are the sources of law for that legal research methodology. Fifth one is what are the nature and structure of the statute as it is regarding the legal research methodology paper presentation. Then Sixth one is interpretation of statutes knowledge in legal research methodology paper presentation. Sixth one is modes of legal research. What are the modes are available, uh, which should be given a importance in a implementation of legal research methodology should be important. Then eighth ingredient is we should know the research process of legal research methodology paper presentation. Ninth one is case analysis, art of advocacy and pleading, and legal reasoning like common sense. Like legal reasoning is essential in element in legal research methodology paper presentation. Then eighth one is ninth tenth one is of observation of agri code of practice and also academic. Both includes observation regarding the legal research methodology paper presentation. Then 11th ingredient is social survey and sampling. Every legal research methodology should mandatorily contain its topic oriented social survey and sampling analysis. It is an important ingredient. Then 12th one is every every legal research methodology paper presentation should enriched with questionnaire and schedules. Then 13th ingredient is every legal research methodology paper presentation relevant to specific topics should contain a report writing. That is the spirit of this legal research methodology paper presentation. And we should aspirant of that report writing regarding the topic we have taken in legal research methodology paper presentation. And finally, we should know the computer application in, and we should know the computer application update version in legal research methodology, and particularly related to our topic. In that angle only we should do the legal research methodology paper presentation for our specific topic. This is an thanks to all jurists, all law aspirants. Thank you.